Good morning, everyone. If I can have your attention, please. My name is Joseph Lentall, and I'm the chair of the Assembly Committee on Codes. And I will be presiding over today's hearing. I'm joined this morning by Assemblywoman Marge Markey to my left, Assemblyman Michael Montesano to my right, and as most of you in the audience know, the subject of today's hearing is the statute of limitations applicable to sexual abuse against minors. Our purpose today is to examine whether the statute of limitations for sexual abuse against a minor contained in existing law warrants amendment as provided for by Assembly Bill 5488, sponsored by Assemblywoman Markey, to allow additional time for prosecution of criminal and/or civil actions against those liable for the commission of such acts. The focus of today's hearing will be to examine the effect and long-term impact these abhorrent acts have on victims of such abuse and their families. I would like to thank today's speakers in advance, as I am certain their testimony will be interesting and informative. Assemblywoman Markey.
Thank you, Joe. I'd like to thank Chairman Lentall for convening this hearing of the Assembly Standing Committee on Codes. I also want to thank my Assembly colleagues who have come to hear this testimony of an impressive panel of witnesses. We all know that childhood sexual abuse has a horrendous personal impact on victims and their families. Researchers tell us that 1 in 5 children in America is a victim of childhood sexual abuse, most of it at the hands of family members or acquaintances, or by other people they trust and respect. Because most victims of this abuse are not able to report what has happened to them until they are well into adulthood, professionals say that our current law is inadequate. Existing New York law enables many predators to avoid the consequences of their immoral and illegal acts by running out the clock, taking advantage of our arbitrary and out-of-date statute of limitations. The bill that is the subject of today's hearing, A 5488, the Child Victims Act of New York, will extend the statute of limitations for these crimes. It will provide victims of abuse a greater opportunity to have their day in court. It also means that New York has the opportunity to become a leader in providing justice for previous victims of childhood sexual abuse. And in doing so, we will continue to protect the future generations of New York children from abuse by exposing pedophiles who have previously been hidden. We have become all too familiar with the horrendous personal impact of these offenses on individual children and their family. Today, we look forward to hearing from experts of professionals who get a better understanding of the enormous impact that childhood sexual abuse also has on all of society. I want to thank all of those with us this morning for the great work that they do day in and day out to assist and comfort assault victims and their families. I'd like to say a special thank you to my staff and to the staff of the Codes Committee for the many years of work that they have dedicated to this bill and for all their help that they have given. We look forward to hearing your views and to expanding our knowledge as we deliberate on this legislation.
Thank you, Marge. The first witnesses will be a panel of witnesses in no particular order. Dr. Ted Miller, Director of Public Services Research Institute Pacific; Henry Miller, former president of the New York State Bar Association; and Dr. Cynthia Mercado, Associate Professor of Psychology at John Jay College. Would you folks please come up if you're here?
Sit.
Yes. So if you haven't worked out an order, we'll start by the witness list and start with you, Dr. Miller.
Thank you. I am a principal research scientist at the Pacific Institute for Research and Evaluation in Calverton, Maryland. PIRE is a nonprofit organization founded in 1974. We specialize in preventive health research and its translation to practice. I have more than 20 years of experience as a health economist, analyzing the incidence and costs of sexual violence in the United States. My first work in this area was funded by the National Academy of Sciences. Subsequent studies were funded by the National Institute of Justice, the Rape Prevention Education Program of the Centers for Disease Control and Prevention, and the Children's Safety Network Economics and Data Analysis Resource Center, EDARC. I founded EDARC, and I've directed it for the U.S. Health Services, Resources and Services Administration since 1992. Our national estimates of sexual violence and child abuse costs are widely cited. The U.S. Department of Justice uses them in regulatory analysis. We provide periodically updated cost estimates by state, and we recently finished or are doing focused incidence and cost studies for Iowa, Michigan, Minnesota, and Wisconsin. I also recently worked on the cost savings to government from the Nurse Family Partnership programs in New York City and New York State. A major benefit of these programs is the reduction in child abuse among low-income families with a first baby. Let me turn now to the substance of my testimony. Did you ever walk into your child's first grade classroom? Think of the faces, grins, voices excited and loud. Were there any tears? One child in that classroom probably was raped by age 11. 2 probably were raped by age 17. Kids in elementary school are raped by adults, family, teachers, coaches, people trusted to care for kids. Those adults flatter, cajole, threaten. They enforce a code of silence and secrecy. Nationally, rape costs more than 3 times as much as drunk driving. From ages 5 to 19, I estimate it accounts for 1/4 of all injury costs. That's more than the cost of road crashes, physical assaults, or falls. The largest cost factor here is pain, suffering, and lost quality of life. It's children who are withdrawn, do poorly in school, turn to drugs, slit their wrists, hurt people. It's wives divorced, battered, drunk, heartbroken. It's a sincere new parent trying to convince a spouse that parents should introduce their children to sex as toddlers. In New York State, I estimate that child sexual abuse costs more than $1 billion a year. The bill for medical and mental health treatment, police services, victim services, adjudication and sanctioning alone is $100 million per year. Adding other child rape would double those costs. The bill is more than $400 per child in the state. A single case of child sexual abuse costs $230,000. The medical spending resulting from sexual abuse exceeds $15,000 per victim on average. It includes short-term costs of treating physical injury, depression, sexually transmitted diseases, and pregnancy. Most of the medical bill, however, arrives years later, and a lot of it's mental health care. 2 large studies that tacked identical twins into adulthood have looked at the long-term consequences if one twin was raped or sexually assaulted as a child and the other was not. And the advantage of those studies is they're genetically identical. They've been raised the same way. The difference between these children is one child was raped, one child wasn't. And sexual assault had far-reaching effects. The victims lived on the edge. They struggled in relationships. Wrong page. There are others. They were twice as likely to abuse drugs, 1.5 times as likely to abuse alcohol, 1.7 times as likely to smoke, 2.7 times as likely to attempt suicide, 2.6 times as likely to be raped again as an adult, and 7.5 times more likely to be divorced. Those events lead to medical spending and a variety of costs to government. Sexually abused children tend to be depressed, trapped. They do poorly in school. They earn less as adults. Kathy Spatz-Whittam found that they have the same elevated risk of becoming violent criminals as physically abused children. Sexually abused children often are adults in trouble before they finally get mental health care. For some, effective treatment requires confronting their abuser. For some, it requires assuring others will not be assaulted by their uncle, their scoutmaster, their pastor. That should happen in the legal system. Police and the courts investigate the sexual abuse claim, assess its validity, and impose appropriate sanctions. They provide a controlled environment where violence will not erupt and false accusations will be exposed. Unfortunately, by the time kids are old enough and enabled enough to speak up, the statute of limitations often has expired. That denies them a safe road to justice. I hope you change that. Thank you.
Henry Miller. No relation, I assume.
No relation, but I am in awe of Dr. Miller and find myself in complete agreement with every word he said, and I'll try not to repeat myself. While I am past president of the New York State Bar, I, of course, speak for myself today. And by way of background, I was once on a diocesan committee invited by Judge Fusco from the Bronx, because he was a friend of the Cardinal, to give some advice to the Catholic hierarchy, which was quite an honor. And I remember speaking to them and saying, don't cover up anymore. Don't transfer these pedophile priests. And that was the thing that was going on, okay? I myself, I should tell you, am a product of Catholic schools. From grade school to law school, I was never abused. But I speak strongly in support of this bill and compliment Assemblywoman Markey and all the rest of you for being before it. My perspective is that of the practicing lawyer. I can tell you, to put this all in perspective, these statutes of limitations, and this is the fundamental point, are not fundamental rights. They're pragmatic rules to protect against stale claims where memories have faded, witnesses have gone away. But they're not fundamental rights. And they weren't much in existence before, I'd say, the 17th century. In the olden days, claims could be made perpetually. The early hostility was there when these statutes came into existence. Judges tried to create exceptions. There are still exceptions being created. There are like 7 states that don't have statute of limitations for felonies. And why should you? I mean, things like murder and rape, why should you have a statute of limitation for that if you can properly prove the case? But I think the pendulum has swung. Now statutes of limitations are very common. And of course, powerful forces want them. If you're sued frequently, like a tobacco company, wouldn't you want a shortened statute of limitations to get rid of these claims? They're not fundamental rights, though. And their injustice is being done. Generally, not just in the sexual abuse area, there are some people whose claims are barred before they were aware, let's say they were harmed, discriminated against. Famous Supreme Court case. Here in Manhattan, the DA has had to drop hundreds of cases in the last number of years because the statute ran, even though they had significant evidence, including in some cases DNA. That is not acceptable. Of course there are reasons for these statutes. Memories fade, witnesses go away, but very often there's no prejudice in making that claim. I originally wrote the article, which is the reason I was invited, and I do very much appreciate that I have been invited, for lawyers. Because I was talking about, is it moral for you, Mr. Lawyer, to raise the statute of limitations when your client admits, I did the wrong. But the more I got into it, my main audience was you, the legislators and the judges, because I feel